Hi friends, in this video we are going to deal with the important judgment titled Ayaz Ali versus Prakash G Goyal and others, pronounced on 20th July 2021. This judgment deals with that the court cannot grant liberty to the plaintiff to amend the plaint while rejecting it under Order 7 Rule 11D of Code of Civil Procedure. To know about the synopsis of the case, please watch the video fully. The facts of the case would be that Ayaz Ali, the appellant plaintiff, instituted a suit before the civil judge. Prakash G Goyal, the first respondent, filed an application for the rejection of the plaint on the ground that it was barred under classes B and D of Order 7, Rule 11 of the CPC. In allowing the application, the civil judge directed the appellant to seek proper relief and pay court fee thereon within 15 days, otherwise appropriate order will be passed. The order of the trial judge permitting the appellant to carry out an amendment for seeking appropriate relief was challenged before the High Court. The single judge held that since the plaint was rejected under Order 7, Rule 11D of CPC, there was no occasion to direct that an amendment be made to the plaint. Therefore, the appeal is before the Supreme Court. The learned senior counsel appearing on behalf of the appellant plaintiff submitted that the High Court has erroneously upheld the finding of the trial judge that the application under Order 7, Rule 11 of CPC had to be allowed. The Supreme Court has held that Order 7, Rule 13 of CPC provides that the rejection of the plaint on any of the grounds mentioned in Section 2.2 of the CPC shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. The definition of decree in Section 2.2 of CPC shall be deemed to include the rejection of a plaint. Hence, the order of the trial court rejecting the plaint is subject to a first appeal under Section 96 of the CPC. The High Court accepted the plea of the first and second defendants that the trial judge, having allowed the application under Section 7, Rule 11D of CPC, was not justified in granting to the appellant liberty to amend the plaint by seeking appropriate reliefs and paying the court fee. In this context, it is necessary to adhere to Order 7, Rule 11 of CPC, which deals with a situation where time has been fixed by the court for a correction of the valuation or for supplying of the requisite stamp paper. Under the proviso, the times of fixed shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by a cause of an exceptional nature from complying within the time fixed by the court, and that of refusal to extend time would cause grave injustice to the plaintiff. The proviso evidently covers the cases falling within the ambit of classes B and C and has no application to a rejection of plaint under Order 7, Rule 11D of CPC. In the circumstances, the High Court was justified in concluding that the further direction that was issued by the trial judge was not in consonance with the law. The appellant is at liberty to take recourse to the remedy against the rejection of the plaint as prescribed by the CPC. Friends, to conclude, in this video we have seen that the court cannot grant liberty to the plaintiff to amend the plaint while rejecting it under Order 7, Rule 11D of CPC as per Ayaz Ali versus Prakash G Goyal and others case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.